present via Zoom as well.
Morning, Judge.
All right, what is this on for? It says motion to increase bond.
Yes, Judge, I did not file a motion. So what happened in this case, Your Honor, is that this is a media case. He was arrested for punishable by life crimes. He should have been held no bond. However, this is one of those charges where the PBL comes in at the very end of the charge, and I think the clerk's office made an error, allowed him to bond out prior to seeing a bond appearance or prior to going to bond hearing. Somehow I think he was given standard bond of $21,000, $10,000 on count 1 and count 2, and then $1,000 on count 3, Judge. My issue, Judge, is that there's no stay away order on the case yet. That's why, Your Honor, asked the defendant to be present. I also am very concerned that the defendant has been essentially terrorizing the victim. I mean, the victim's 14 years old, and there's been a lot of...
Since the arrest?
Since the arrest, Judge, he's been very communicative he's been very vocal on social media, there's been videos of the victim drugged by this defendant leaked online. Your Honor, on this case, we do have DNA showing that the defendant's sperm was on the victim's clothing.
Your Honor, may I ask why any of this is appropriate considering no motion has been filed?
Yeah, that's the thing. I don't like being ambushed with all of this. This is...
Nor do I, Your Honor. This is entirely inappropriate.
If, in fact, the state was seeking a motion for pretrial detention, they should have done it. I mean,
well, Judge,
now, as far as the stay-away order is concerned, I can certainly do that, but I just can't go ahead with allegations from the state without giving notice to the defense. I mean, certainly I would hear it, but I can't do this in a vacuum like this. So the only thing that I know that this was reset for, which was advised to me the last time, is that the stay-away order was not properly presented, and I'm ready and able to do that at this time.
Judge, you are the first appearance, Judge, regarding the information that was filed, Judge. He was charged with a total of 6 counts, Judge. And they're different. They're all different from the charges, except for
Again,
one.
Your Honor, excuse me, I have to interrupt. This is entirely...
Hold on. Mr. Terrace, hold on. Let her finish. Just let her finish. I'll allow you to make your argument. Go ahead.
Thank you, Your Honor. He has been charged with 6 counts. One of them is the same, but there's 5 additional counts, Your Honor. So Your Honor does have to set bond on those counts. And then the stay away order has to be set. I will be filing a motion to increase bond. And I understand that Your Honor does not want to be ambushed. I will file that at a later time, but I did want to put the court on notice that with regards to the other bond amounts that need to be set, Judge.
All right.
So we definitely have to address bond.
Okay. Now, did you have a response, Mr. Torres, and then I will deal with the information.
Yes, Your Honor. We don't. There is no motion pending before the court. The state, no one. Our side certainly did not ask for a schedule bond. That was something that the state of Florida decided to place on this case. Those charges were higher charges, and they were downfiled. Doesn't matter that there was more charges that were listed on the information. These are downfiled charges. Mr. Nowak is out on constitutional bond. There's no motion pending before this court, and there's no need for Ms. Garcia to just ambush us with additional information that she feels the court and the media in her speak should hear. So we are entirely prepared to address a motion that's before us. Not another word needs to be said regarding a motion that's not pending before this court. We do and are prepared to address the no contact situation today.
Okay. Now, first things first. First thing I have is I have an information that's been given to me by the clerk that was filed on September 14th, which was 3 days ago. And again, I have many cases on my calendar. Has this defendant been arraigned on this information?
He has, Your Honor.
He has, Judge.
He has. Okay, so he has been arraigned, and I am looking at there are a total of 6 counts. I, at this point, do not see that there are any non-bondable offenses, and there appears to be a second-degree felony for count 1, second-degree felony count 2, 3 is also second-degree, 4 second-degree, 5 is a first-degree misdemeanor, and 6 is a third-degree felony. So have all of the bonds been addressed at the time of the arraignment?
No, Judge.
No, Your Honor.
Okay, well, that's what we need to do as far as that is concerned. And I will... What was he out on previously? Let's just start with that.
He was out on count 1 and count 2 for $10,000 each. And then count 3 on the information was a misdemeanor, so that was $1,000. So right now he has a total of $21,000 bond.
Okay, so 1 and 2. So what was added in the information?
So the counts 1 through 4 are all second-degree felonies. Those were not on the information on the
Were not originally charged?
Correct. Also, Judge, count 6 is interference of custody. That one also was not charged. Count 5 was charged as count number 3 on the arrest form. So that one should stay $1,000.
So then what was the original 10,000? If you're saying that 1 through 4 was not charged and then 6 was not charged, then what was the original charges where he got the two $10,000 and then $1,000?
So the original charges was count 1 was engaging in sexual activity with a child in familiar custodial authority. That was actually a PDL, but that charge, when it's input into the arrest form, it looks like an F1. So on that count, he was given $10,000. Then on count 2, it's sexual battery of a victim 12 to 17 years of age. That's an F1. That was another $10,000 bond. And then count 3 is count 5 on the information.
Okay. All right. So as it relates to the new information, the court is going to, on count 1, the defendant will be given a bond of $10,000. On count 2, defendant will be given a bond of $10,000. On count 3, defendant will be given a bond of $10,000. On count 4, defendant will be given a bond of $10,000. On count 5, that will be a $1,000. And count 6 will be $5,000 bond. Does corrections have that? Well, clerks have that as well?
Yeah, I have it, Judge.
Okay. So he is going to need to post those additional amounts. If it was $21,000 originally, it's now going to be $46,000 additional bond. That's as to that issue. Anything further on that issue? And then we're going to get to the stay-away order.
So, Judge, I do think it's important to note that he is a California resident. So I would ask that Your Honor consider that when setting the bonds. Are these standard bonds, Judge?
I do not know what is considered a standard bond on these, but these are the bonds that the court's going to be giving.
Okay. So, no, Judge, I'll be filing a motion to increase bond due to the facts of the case. In addition to the bond, Judge, it's just a stay-away order I think that we need to address today.
Understood. All right, anything further from the defense as to the bonds for right now?
Your Honor, I don't see that the state has laid any grounds for why the bond amount should be increased. We believe
we're not there yet. We're not there yet. There's no discussion right now. That's not what's before the court. The court just is setting bonds on the new counts.
These counts are downfiled. I just want to make that clear from the record, even though there's more of them.
Understood.
But we would object to the entire bond amount increasing, considering these are downfiled charges.
Okay. Your objection is noted.
Other than that, no, Your Honor.
All right. As it relates to the stay-away order, okay. So apparently these are minors. If I can have the defendant sworn.
Mr. Nowak, can you unmute yourself?
And raise your right hand. Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so you can put your arm down. Can you tell me your full name and your date of birth?
Michael Eugene Nope Jr., born August 10th, 1983.
All right, thank you, sir. All right, so you are currently charged under case F21 14438 with several counts involving a minor victim. And the minor victim is identified as T like Thomas, S like Sam. Do you know who that is?
Yes.
All right. Sir, you are ordered that you can have no contact with TS. And when I say no contact, that means no direct contact or indirect contact. Indirect contact includes you cannot communicate with this individual via social media, you cannot call, you cannot text, you cannot reach out to this individual or in some way attempt to communicate through a third person. Do you understand that, sir?
Yes, I do.
All right. Now, I will just advise you and admonish you. This means what it says. I do not know whether or not you were given any type of a stay-away order, but as of right now, this stay-away order is in effect in that if you violate any terms of this stay-away order, that may be grounds for your bond status, your pretrial release status to be revoked, and you will be immediately taken into custody. Do you understand that, sir?
Yes, I do.
Okay. Anything further on that issue from the state?
No, Your Honor.
Anything further from that issue from the defense?
No, Your Honor.
All right. That is all that the court has before me. Are we done? Ms. Garcia?
I believe so, Judge. I just want the defendant to be aware that he should not be posting any social media posts or anything about this case, about the victim in this case. I know that there was a video of the victim leaked on social media. I'm concerned about the victim's, well-being regarding this case. So I just want to make sure the defendant's well aware that if that happens, we will be filing the appropriate motions to avoid that from happening.
All right. Well, just so it's
Judge?
clear. Yeah, just so it's clear. I just want both sides to know allegations are allegations. I certainly will respond to some type of evidence shown to the court that the defendant has somehow violated the court's order. Let me hear from the defense.
Judge, I just want to make clear for the record as well that this arrest, Mr. Nowak has been compliant and has known about this investigation for far before his arrest, has come down and voluntarily submitted 2 warrants along the way because he has nothing to hide. Any allegations that the state is making about their fear that he might have been tampering or attempting to scare the alleged victim via social media, there's no order saying that he is not allowed to use social media. And I also would like to make clear that it took the state till 4:56 p.m. on the night before the arraignment to file an information here, and a reduced one. If they were so scared, they had ample opportunity to file a motion in the meanwhile, and they failed to do so. So I don't believe that Your Honor has taken into consideration any of the arguments that they've put forth regarding why they believe bond should be increased, because that's inappropriate.
We're not there. I'm not even entertaining it. So let's not even. I don't even want to hear anything about it because nothing's before me as to an increase.
Well, Your Honor has the ability to set the additional counts at ROR.
Well, I'm not. I can tell you I'm not. Based upon the only thing I have in front of me is an information. That's what I've decided as far as the bond is concerned. That's it. Nothing more, nothing less.
Well, we would object to Your Honor taking into consideration any of the statements made by Ms. Garcia in reaching that determination.
Okay. Now, however, I do need to just advise Mr. Nowak, based upon some of the arguments. I don't know what is out there that has been posted, but I will advise Mr. Nowak that if in fact there is evidence shown to the court that you have somehow been responsible for submitting some type of social media involving this victim, you may have a First Amendment right, but it is limited. And if the state can show that this was done with some type of intent to either harass or intimidate a witness, that's serious. So just keep that in mind. You certainly have a First Amendment right, but if you do something that in somehow is intended to intimidate this witness, then the court will listen to what the allegations are and what evidence the state has presented. I think that can be the last word on this matter. I have a December 3rd report date. What is that on for?
I believe that was just for the status, Your Honor, case disposition, regular.
Okay,
course.
perfect. All right, as of right now, that's the next date that we have on this case, okay? Thank you, everyone.
Thank you so much, Judge.
Thank you, Your Honor.
Take care. All right, bye-bye.